Good morning, everyone. Thanks very much for joining us. I'm Lauren Brinjack, Senior Director of Legislative Affairs for the Pennsylvania Restaurant and Lodging Association. As you all know, Governor Shapiro signed into law last month two pieces of legislation affecting liquor licensees, both of which were supported by PRLA. One was an omnibus bill making numerous changes to the liquor code, and the other was legislation that would allow our restaurant and hotel licensee members to sell ready-to-drink cocktails to go. Both pieces of legislation take effect in the next couple of weeks. And today we are very happy to have the executive team from the Pennsylvania Liquor Control Board here to give an overview of these new laws and to answer any questions that you may have. And as Eric noted, if you have any questions as we're going through the conversation, please just put those in the chat, and we will do our best to make sure those questions get answered. So I will, at this point, I will turn it over to the team at the PLCB to get started.
Thank you very much, Lauren, and good morning, everybody. I am Mike Fagoda, Director of Legislative and Governmental Affairs and also Board Secretary for the Pennsylvania Liquor Control Board. We have our executive team here to discuss Act 57 and Act 86, answer any questions you might have, take some questions and answers away for future discussion points as well, because while the acts are signed into law, there are some operational questions that we're getting from the meetings we are taking and certainly having to make some decisions around that in the future. I will, Lauren, if it's okay with you, do you want to start with Act 86? That might be the smaller one to go through.
Sure.
Okay. So as Lauren had mentioned, Act 86, which takes effect on September 16th this year, allows ready-to-drink cocktails. So those are 12.5% ABV by alcohol by volume, and 16 ounces or less in a can, to be sold with an additional permit for off-premise sales, almost like beer and or wine to go. Okay, so we are getting ready for that implementation date. We have permitting and testing underway. I'll let Tish Albert talk about that in a little bit. We're also working with the supply chain side to make sure any and all forecasts for products that you guys may want, we can have and we can sell to you. So there are numerous nuances to that legislation. So if you just bear with me 1 second, I'll share my screen and bring up the legal summary. So bear with me 1 second. Okay. Eric, I asked for permission to share. Okay, there it is. Okay. So if you're seeing my screen at this point, you should be seeing the legal summary that's available on the PLCB website under the legal tab. And this kind of goes through, the Act 86 from a legal perspective, but a lot of it is operational as well. So if I could, Tisha, I know I saw Corrine on here as well. Can you and Corrine and Andy, if he's on here as well, kind of go through where you guys are at from a permitting process for Act 86 and also the ramp questions?
Sure. Hi, Tisha Albert. I'm the Director of Regulatory Affairs. I oversee the Bureau of Licensing and the Bureau of Alcohol Education. So as Mick noted, we are have the RTDC, the ready-to-drink cocktails. We're working with our third-party vendor to test, which we have been able to do successfully over the last week, a RTDC job. So when you go into PLCB Plus in your account, there will be an amendment that you can go to add this ready-to-drink cocktail permit to apply. We anticipate that that will happen this week, hopefully in the next few days, which we will work on communication to send out to licensees via an e-blast, as well as we will make sure Lauren and PRLA leadership receives the email as well to assist if needed. So what we will look for when a licensee applies for a ready-to-drink cocktail permit is ramp certification is a requirement of to receive this permit. What else we will look for is if there is a pending non-renewal action with your license. So those are the two key criterias. The cost of the permit is $2,500. So when you go in to apply, you will pay the fee. We'll do the review process. Now, if the if the licensee is eligible to have this permit, we will not start issuing any approval letters until September 16th, the date of the act, when the act goes into effect. So right now, again, I think our plan is this week to release that availability to apply, and we will start our reviews as soon as we receive them. We anticipate a couple thousand applications coming in at one time. So with that and with resources, we will definitely work through as quickly as possible. We know this is a huge opportunity for licensees. So we are doing everything we can to get this up and running prior to the effective date. If there are any ramp questions, how to become ramp compliant, can certainly go through that with any licensee or this group. So if there's any questions, Mick, I don't know if you want to just go through everything else and then we'll open it up.
Yeah. I mean, I'm monitoring the chat in case something comes up. So assuming as a business you decide to apply for an RTDC permit to sell RTDs to go, as Tisha alluded to, that application will be hopefully open this week and we'll issue approvals on the 16th. What does that look like going forward? From a business perspective, it's a lot like selling beer to go, in that you are capped at the 192 fluid ounce limit, or the old 2 6-pack rules for beer. From a renewal standpoint, it's a lot like a wine expanded permit. So for those that do not have a wine expanded permit on this call, you will be upon renewal, you will owe 2% of the amount of RTDs you bought for off-premise resale. Will be due at the time of the renewal of your license. Moving forward with RTDs, like I said earlier, we are working through forecasting for additional supply chain. We're trying to look at bringing in additional requests for products. So with this group, I don't know if you have worked with Jay Magruder and the wholesale team on any forecasts yet. I believe Jay's on this call. Jay, if you're here, do you want to kind of talk through the forecasting end of things?
Yes, I can. Good morning, everybody. My name is Jay Magruder. I am the Interim Director of Wholesale Operations for the Pennsylvania Liquor Control Board. So if, similar to what Mike just said, if you are interested in the selling or using or purchasing on this product, for Act 86 for off-premise consumption, we are looking to or working with our vendor partners in regards to procuring more products for that. We are, if you go out onto our public website under the RTDC link on our public website, there is a link to the items that we currently carry in the state. There's over 100 items, and on that spreadsheet, there are columns out to the right to request an initial forecast or a 90-day forecast or 90-day replenishment forecast if you're so interested. So I would encourage that if you are interested in carrying that product, work with our wholesale team. I can actually drop my information into the chat along with the link to the wholesale inbox. Please work with us to send that information over, and we can work with you in terms of procuring that product and getting it into the right locations where you purchase, whether that's via LDP or picking up at a licensee servicing center or fine wine and good spirits store. And we can get that product there in a timely manner so that you're ready to go once these permits go live. Thanks, Mike.
Thank you, Jay. So just kind of going through the chat here, trying to answer Andy, your question regarding wine expanded and a RTDC permit. They're two separate and distinct permits. The legislation in Act 86 created the RTDC permit, so you can apply for one or both or neither of the permits. That is a business decision for you to make, but they have their own fees and renewal structure as well. Okay. So I saw Doug Hitz on this call. Doug, there's a question in here from Carla regarding the 2% renewal fee. Those are answered, Carla. The 2% renewal fee for RTDs and for the wine expanded permit are separate and distinct renewal fees, and they will be calculated as such. I just wanted to kind of bring you in here from the Loop perspective that there are two different categories of products. So Loop but they're only going to be on one purchase order on Loop, correct?
Yeah, that's correct, Mike. So when a licensee purchases product from us, it's essentially under one, I don't want to say a purchase order from your side, but it's one order within Loop. So as a business is conducting their normal course of business, you're going to be purchasing both wine and RTDs, and they'll be going on the same order and the same invoice. But to Mike's point, the renewal calculation for the wine expanded permit is one renewal calculation for your wine purchases, and the renewal fee for the RTDC permit is a separate accounting or reconciliation you'll need to go through to submit your renewal fee.
Thank you, Doug. And Carla, kind of going through this a little bit more, I think you're also asking as far as what you're selling for on-premise versus off-premise. Are you able to respond to that? Is that clarifying what you're asking? Yes. Okay. So I believe that is the business decision for you and the record keeping on your end. Doug, Jason Worley, help me out here. That's kind of accounting on them, because we're only selling them one group of product, correct?
Yeah, that's correct. So the purchases you make from the PLCB, I guess I saw your follow-up question there, Carla, with is the 2% off purchases or a set fee. So when you purchase product from the PLCB, each licensee is entitled to their 10% licensee discount. So whatever the current retail price is on that day, you get 10% off of that. And that goes on your invoice, and that's what you pay the PLCB. When it comes time for renewal, that's a calculation you need to make going through your records, totaling up your purchases, and then essentially sending in 2% of that value. So it's not done at the time of purchase, it's an annual exercise.
Hey, Doug, this is Rod. If I could just one little caveat about the 10% off. Sometimes we will have a special promotion under our customer service program, and by statute, we can't consider that price. So it's 10% off what the normal price is, right, Doug?
That's correct.
Yeah.
Yeah, it's 10% off whatever the retail price is, yeah, assuming that the item is not in the CRM program.
Yep.
Yeah.
And Andy, just to further your question, it's the 2% off a wine or RTD sold for off-premise, not all of the wine or RTDs you may sell for on-premise and off.
Yep, there it is.
Okay, continuing on the RTD questions is This based on cost to licensee or the final sale price to customers. This will be off of, I believe, the acquisition price from the LCB or a licensed Pennsylvania manufacturer. Okay, from Alex, just trying to clarify, our distributor licensee is now permitted to carry the WEPs or so. Act 86 did allow for RTDC permits to go to a beer distributor or an importing beer distributor. They did not get the privilege to sell wine to go. It is only the RTDs. And they are the same renewal structure and same fee structure as you are as well.
And they can only sell to non-licensees.
Thank you, Rod. I apologize. I'm trying to keep up with the chat here. So if you're selling, Megan, thank you for the question. If you're selling RTDs for on-premise consumption, that is, assuming you have a restaurant liquor license, that is an inherent privilege in your license. You do not need an additional permit. The permit is only for off-premise sales. Okay. No, Stephen, the same 10% discount that you received. I'm sorry, go ahead, Ron.
Could you read the question so everyone knows what you're?
Not a problem.
Thanks.
Not a problem. That's good. Good catch. Stephen Sobel asked, is there a different discount allocated to wholesale licenses versus retail licenses when purchasing? No, the distributors are getting the same 10% discount off the LCB price as you are, adding the caveat that Rod had mentioned earlier, is it's a product under our CRM program. Neither you or the distributors are getting that discount, or that extra sale, I should say.
So, hey, Mike, I do want to make one clarification, if I could, please.
Absolutely.
On the 2% renewal. So, under Act 39 and the wine expanded permits, the 2% renewal is, as you correctly stated, 2% of purchases made by the licensee from the PLCB. With Act 86 and the RTDC permit, it is 2% renewal based on acquisition cost from the PLCB and licensed PA manufacturers. So it's essentially, if you purchased that product for the purpose of off-premise consumption, regardless of the source of your purchase, whether that be the PLCB or a licensed PA manufacturer, those totals need to go into your total to calculate your 2%. And yes, Ken, does a licensed PA manufacturer include PA distillery or limited distillery? Yes, that's what I'm referring to when I say a PA licensed manufacturer. It's a distillery or limited. It's a manufacturer who meets the criteria within the Act. But generally speaking, it's a limited distillery.
Okay, Chris McNichol asked, doesn't the 2% renewal fee effectively alter the statutory 10% discount on the purchase of RTDs a licensee receives? I mean, in a way, yes, Chris. I mean, that's what the statute says to do it. So what we are selling to you is 10% off the shelf price at that time, and then upon your renewal. I guess the distinction I'd make for you is, if you're buying RTDs at a given day, I don't know if you're selling that for off-premise or on-premise consumption, right? Because we're only selling you the RTD. What you choose to do with it, if you get a permit, is up to you. So you are certainly able to run your numbers and differentiate. Are you going to get this permit and effectively go to an 8% just by math discount or not? But I think you're understanding that correctly.
And Mick, there was a question further up from Andy. She asked, and the permit is only for prepackaged can items not in-house made, i.e. a slushie made with liquor, not malt-based.
Thank you. That is correct. So it is not beer-based. This is RTD, so it is spirit-based, and it is already prepackaged in a container. It's not something you can open and pour in because we don't have mixed drinks to go anymore, right? So it is a closed container that you are selling for off-premise consumption. Thank you, Lauren. Okay. Okay, Carla just asked, do RTDCs need to be recorded differently than on-premise sale? For example, being one POS system or a retail sales category, just not understanding how one bottle of liquor can be dispersed into partial sales and recorded as such. So Carla, you're asking for purposes of, I'm assuming, the renewal fee, and then obviously your record keeping internally. So assuming you're going to have to identify products. So I'll just use an example, and the PLCB team, if I'm struggling or missing this, please stop me. If you're buying, say, a case of stateside, the Surfside iced teas, and you're selling that to go, obviously you're recording that as RTD for off-premise sales. If you're breaking that down and selling 4 of them, you're going to have to record that as such as well. Because again, we sold, assuming we sold it to you, we're selling you that case, that 8-pack. What you're choosing to do with it then is kind of on you. Rod, Doug, did I get that wrong?
I think you got that one right, Mike. It's
Okay.
you got to be able to essentially track your sales for the purposes of your renewal.
It's one of those things they may want to write into the chief counsel so they have it in writing because it's a bit complicated.
Okay. Carla just further asked, in a golf situation, we would split cases depending on demand. Okay. I'm sorry, I got to scroll back up here 1 second. Stephen just asked, are we able to use liquor products bought through the PLCB, such as a vodka or a gin, batched and bottled in-house and sold to go? So, Stephen, if I'm understanding your question correctly, no. So an RTD an RTDC, I should say, is actually strictly defined as something in 12.5% ABV in a container up to 16 ounces. So you're not able to sell beyond that with that permit for sold to go, I should say. Any further questions on Act 86? As Rod had mentioned, you are able to write into the Chief Counsel's office for legal opinions. I'll get that email address and make sure it's in the chat here.
And I'll add my email address as well in case anybody thinks of any questions after the fact. Feel free to contact me.
Christina just asked, is there any special rules on a Class H license? No, they are treated the same as an R, or in this case, also a D or a ID, should you get the permit. So as I mentioned earlier, there's a lot of overlap between a wine expanded permit and the RTDC permit. The legislature chose the path of least resistance, which, Section 415 of the Liquor Code expands out wine to go. This also then 415.1, which is the RTDC permit and RTDs to go, very, very similar language. So if you have the permit, you have that privilege to sell up to 192 fluid ounces to go in a single transaction. All right. Bear with me one second, Lauren. I wanted to go get the other page. So if that wraps up Act 86, Susan just came in under the wire here. So restaurants cannot create their own cocktails and sell them to go. Correct. This is not mixed drinks to go. The mixed drinks to go legislation or statute that was with the pandemic has not been renewed by the General Assembly. So this is pre-canned beverages that are there to go. Mixed drinks to go, where you are actually making them behind the bar and selling them out the door, would need to be statutorily reestablished by the General Assembly. And that has not happened yet.
And here was one more from Chris McNichol. If approved on September 16th, does the permit apply for the full annual period of the R license renewal period?
Tisha, are you able to answer that, please?
What we're looking at is, depending on when a license renews, there may be some overlap with these RTDC approvals with the renewal. So it's going to depend on when a licensee does renew, especially September, October, November this year. We're still working with our vendor to get through, test the renewal process. So some licensees will have more time or not, but what we will do is work individually with the licensees as they renew, and that it's just going to depend on the renewal period.
Okay. So Dominic's asking, can RTDCs are permitted to be sold as part of the off-site catering permits, correct, but not reported as off sales? So Jason Worley, help me out. If you're doing a catered event, that is treated as on-premise consumption, correct?
That is correct for that location.
Okay. So you would not be cataloging that as a 2% renewal product. You're going to treat that as on-premise, which isn't subject to the permit or the renewal fee.
Correct.
Okay. Ashley Thomas, but can we begin canning them? Ashley, if you can clarify, do you have a manufacturing license versus a restaurant or hotel license? Not yet. Okay. So if you were to become a Pennsylvania licensed manufacturer of RTDs, yes, you'd be able to make an RTD under that license. But on the retail side of the equation, an R or an H license, I'm treating it as mixed drinks to go. So you would not be able to make them yourself because that law is now lapsed. Okay. And an R license that is coupled with Stephen Sobel just asked, can an R license that is coupled with a limited distillery can their own mixed cocktails and sell it to go with an RTD? Jason, are you able to clarify that, please?
I think it tracks the same answer you just gave to the previous question, Nick, that if they have a limited distillery license, they can certainly produce a canned cocktail that meets the definition of an RTD and then sell that pursuant to that license. The fact that it's coupled with an R, I don't think changes anything. That doesn't really open the door for you to be able to sell a mixed drink that you're simply just mixing and pouring into a can. I'd also remind too that there's the limited alcohol content on these RTD beverages, which are capped at 12.5%. So that would come into play as well.
Thank you, Jason. Okay. I guess I'll announce last call for an Act 86 question. As always, should you think of something that we have not talked about after this, you are able to reach out to Lauren, she's free to contact me. I did put our chief counsel's contact email in the chat, so you're able to submit any advisory opinion questions you may have for Jason Worley as well. This is an ongoing debate whether or not you guys want to do this. It's a business decision for you. So as you're going through and you generate those questions, please reach out. Please feel free to ask. This is something we'd like to over communicate and over answer a question rather than leave you in the dark. So with that, I will switch over to talk about Act 57. Act 57, as Lauren alluded to earlier, is the omnibus bill that was also running concurrently with the RTD bill. So Lauren and I had a very, very fun summer in Harrisburg. So if you bear with me 1 second. Okay, so if you should be looking at the legal summary for Act 57. Now, this goes into effect September 13th as compared to September 16th. And again, this is chock full of changes that impact your businesses. Some of them are distributor-based, and some of them are just retail-based. I'll say this on the initial go-through. Some of these pieces of legislation were not long-standing asks or bills that Lauren and I may have tracked over the course of time. So sometimes when that happens, where stuff gets put in last minute, we may not know the intent behind it because we were not involved in its review. And that did happen here with the omnibus bill. So a lot of things going on here. So, please start putting your questions in your chat if you have any. But I'll just kind of start going through top to bottom here. The omnibus bill did bring back the trailer drop discount. This is a discount program that we have if you're picking up or you're bringing a trailer to us at our warehouse. So our 2 distribution centers, one in Philly, one in Pittsburgh. For the vast majority of you, I don't believe you pick up product that way, but the bill did bring that back. So further here, did make changes to allow club and catering club licenses to extend safekeeping. It mirrors that of the restaurant extensions you guys have had since, I believe it was Act 39 that gave you that ability. So clubs now get to extend. The fee structure is a little different. It's a little lighter than so it is $5,000 for an additional year in first through fourth class counties, and $1,000 fifth through eighth. And that does double as you go through. So this one, actually, the next one up is a little bit of new, but there's some origin behind it. As you may have noticed, there's a proliferation of alcoholic versions of non-alcoholic beverages traditionally. And the one I like to use is hard Mountain Dew versus regular Mountain Dew. So this has crept up to where we've seen co-location of products between the Mountain Dew and the hard Mountain Dew. So now you do need to put signage. If you're going to sell them next to each other, you do have to put signage that identifies the product contains alcohol. This was not necessarily new, but it was very quick to make it into the legislation. And the legislature, in my opinion, was actually trying to get ahead of something for once instead of playing catch up. Additionally, we've seen additional eligible entities for special occasion permits come on. That's really not going to impact you guys overly much, but it is in there. Further, this does overlap with you guys. So the liquor code pretty much had prohibited licensees of one class working from a licensee of another. This now has eased off of that to where you can have some employees who will work for a distributor also work for a restaurant and vice versa. And I'm seeing some questions in the chat, so let me just kind of back over here from Chris McNichol. Does this provision apply if the product is being served by a bar employee or only if a customer has direct access to the two products? You're talking about the signage. So I believe it's where you're displaying both products. If they're behind the bar, I don't believe that provision will be applicable. Jason, do you have any thoughts on that?
I agree with that, Nick. I think the intent here was to capture the scenarios where the product's out on display and directly accessible by the customers.
Okay. And then Megan, you asked a similar question. I think that may address yours, but I'll read your question nonetheless. So if you have all your Bud products displayed behind the bar together and also offer Bud Zero, you need to separate the Bud Zero. No, this is, I think the legislature envisioned this being more, and I'll put it akin to, say, a beer distributor or grocery store where you may co-locate the products on the shelving units. What the General Assembly is seeing in other states is where you literally don't know the difference of what you're buying because the hard Mountain Dew is located right next to the regular Mountain Dew. Oh.
And Mick, just to add to that, I think the intent there was to try to prevent the possibility of confusion amongst customers, particularly those that might be underage. So if you compare that to the scenario where product is kept behind the bar, in theory, your bartender is going to be that gatekeeper to make sure that minors aren't getting their hands on the wrong product in that scenario.
Hey, Jason. Okay. I was kind of going through the employment piece here. I didn't know if anybody has any questions about that. Again, if you don't have it now or something comes up, you are able to reach back out to myself, to Jason Worley, to anybody on this call from the LCB. We'll be happy to answer that, any questions you do have. All right, so continuing on, extended hours food permit for clubs. Shouldn't hit many of you on this call based on what I know of your membership, but clubs were limited previously or currently until the law is in effect, only doing extended hours 6 nights a year or 6 days a year. This matches them to your hours. So you guys, if they get a extended hours food permit, they can do it all year, just like anybody with an RNH. Oh. Okay, now here is one that I think we can all get behind. Happy hour expansion. So previously, the number of hours of that happy hours could be held were limited. This has expanded that, and also included some drink and food and drink combination specials. So we've had previous meetings where some questions have crept up here. So I'll give it a minute for anybody to kind of type a question here. But by and large, you guys can expand happy hours as you need to see it. Okay. Well, if somebody types one in, I'll come back to it. So continuing on, inside advertisements, the cap for the total costs. Okay, Chris McNichol did ask, still no more than 4 consecutive hours per day. Jason, are you able to provide an answer to that, please?
You state the question again, Nick. Sorry.
Yeah, sure. Chris McNichol asked if happy hours are still limited to no more than 4 consecutive hours per day.
I believe that part has remained unchanged.
Okay. Inside advertisements, the caps for the total cost of inside advertisements relating to any one brand has been raised to $750 per licensed establishment. Previously, that cap had been $300. So you may see some more advertisements coming your way. Okay, Christina Turley just asked, still must be posted 7 days in advance. I believe she's referring to the happy hour rules Jason, I believe so.
I believe that also has remained unchanged.
Okay. Going down, manufacturers' hours and extended food permits. I don't know how many manufacturers are part of PRLA, but we'll certainly talk about this real quick. So this is a piece of legislation would allow manufacturers, specifically breweries and limited distilleries, distillery licenses to be open on New Year's Eve every year. And then if they wanted to get an additional permit, it costs $50. They would be able to open up beyond New Year's Eve for one additional day. This stemmed from Representative Freeman's bill, was included in this. So again, I don't know how many manufacturers are part of, or on this call, but they can now open at New Year's Eve up till 2 a.m. And then with that additional permit for $50, do it another day throughout the year. Okay, the non-alcoholic malt beverages, that's really the beer distributor side, so I'll kind of skip that. This one a little bit interesting, the sale or rental by distributors and importing distributors. This involves you guys now that you're able to rent equipment from, they can sell or rent you equipment, a beer distributor can, that they were prohibited to prior to. So I didn't know if there's any questions here. If so, please put them in the chat. Additionally, let's see. This is another one. And Lauren, I don't know if you maybe have background on this because I don't. The self-sponsored event where now a hotel, restaurant, or club may self-sponsored event sell tickets where up to 2 alcoholic drinks is involved. I was not involved in that part of the sausage making, so I don't know the origin of or the intent behind it, but I think it's self-explanatory. Okay. And then continuing on to the temporary extensions. Many of you during COVID had outdoor or temporary extensions outdoor for outdoor seating. This was that provision in Act 81 was due to sunset at the end of the year. Act 57 extended that out and removed the sunset dates. So you are free to have that outdoor seating up to 1,000 feet away across public thoroughfares and go. Now, Tisha, I just want to clarify, they're going to have to do this. They're going to have to reapply upon their renewal, correct?
Yeah. So in addition to the sunset expiring, there is the $220 fee that is now being attached to request the temporary outside extension. In addition, there's still a posting requirement, and the temporary extension will only go through up until your renewal and or validation period. So you still need to apply at least every year and post and go through the process.
Okay.
I believe I saw a question about the
Yep. I'll read it. I'll read it. Molly Gallagher has just asked, Philadelphia has adopted, and she's using air quotes here, or adjacent streeteries with the agreement of the adjacent property owner. Kindly address the process for extension of premises of a liquor license so that liquor can be sold in the adjacent streetery.
So Andy, I don't know if you want to jump in here. Andy's our director of licensing. What I will say is that if this temporary extension goes beyond your into another streetery or road closure, you need that permission from that entity that owns that location and or property. So there will be times where we will ask if you have the permission to utilize someone else's property and or a road closure for an event, because sometimes these aren't for a whole year, they're just certain dates. So we will need validation from you that whether it's a contract or an agreement or a lease or something, to show that you have the right to occupy that area.
Yeah, and you're right, Tish. It's a yearly process. So if anybody has a streetery and it's within 1,000 feet and not more than 1,000 feet away from their licensed premises, they would use this temporary outdoor extension, and they would have to file it every year. We'd get the verification from the city that they have the right to use it. And yeah, I just wanted to add too that after December 31st, anyone that wants to reapply can do so at any time, but there's going to be that extra $220 fee. And it's also similar to the way the temporary extensions are set up through the COVID Act. There's an instant approval for them. So as soon as you apply, you're granted authority to use this area. It's still subject to protest, investigation, inspection on our end, but they do get a chance to use that immediately like they do the free permits.
Okay. Andy and Tish, if you guys want to stay on here, Chris McNichol asked if an extension of premises expires at the end of the year, 12/31/24, at what point can a licensee start the process to apply for another 1-year temporary extension?
So that's another part that we're working with our third-party vendor on getting the fees added for that application. So I would say a notification to us that you intend on doing that. If you want to do it as soon as September 16th, I would reach out to our licensing team, but that may not be possible until we get these fees situated. So you're good until the end of the year, at least until 12/31/24. If you want to file before then, there'll be more communications coming out when we have that piece ready. And we're hoping for it to be close to the week of the 16th. But again, we're up against our software company to figure that part out.
Yeah, and just to piggyback on that, as you can imagine, both acts were implemented and signed within 3 days of each other. So with everything in both bills, we're doing everything we can. But knowing the RTDC act was most priority. But again, we will do what we can to try to get all these other permits and applications ready as quickly as possible.
All right. Thank you, Tisha. Thank you, Andy. Continuing on, moving on to lawful inducement exceptions here. Jason Worley, if you're able to come back on here, this is probably one of my worst sections of the liquor code. So, this was a change. Generally speaking, prior to this, any inducement for the sale of alcohol was prohibited, and the changes in Act 57 loosened that. Jason, if you're able to kind of, want to give a summary of the change here?
Sure. As Mick had indicated, there's generally a prohibition in the liquor code against unlawful inducements to purchase alcohol. There's already several exceptions that have been in Section 493/24 for many years. But the specific changes that come about here are for a distributor or importing distributor to offer and advertise quantity discounts on the purchase of multiple beverages. So that's not really something that would impact you folks directly, but there's also that a manufacturer or licensee may provide a trade buyer with point of sale advertising for liquor or multiple brewed beverages sold by the manufacturer or licensee if the total cost of such advertising relating to one brand is not more than $750 per licensed establishment. So this isn't so much a change in the content of what is permitted. It's really just a raising of the monetary limit. It used to be capped at $300 per brand per establishment. So that would apply to a promotional situation that you might have on licensed premises, whereby you're getting support from the manufacturer or a wholesaler as to that point of sale promotional or sales advertising. That cap again is raised from $300 per brand up to $750. And then the last change is that a limited winery can now offer discounts to non-licensees, including quantity discounts on products sold for off-premise consumption.
All right, thank you, Jason.
Sure.
All right, and that kind of completes the overview of Act 57. Again, questions, please put them in the chat. But that kind of completes Act 86 and Act 57, Lauren. I didn't know if there's anything you wanted to wrap up with. Obviously, we have the executive team here, so if something comes up in the next couple of minutes, we're happy to answer it. But I'll continue to offer, if you should think of questions after this, please send them our way. We're happy to provide any information we can.
Yes, thank you, Mick. We really appreciate your time and everyone's time from the PLCB today. A recording of this call will be emailed to everyone who registered. So for anyone who wasn't able to attend or had to drop off the call, they'll get a full recording of this. And please feel free to also, if you have any questions, send them to me as well. And I'll communicate with the team at the PLCB and get your questions answered. And more information obviously will be coming out about the RTDC permits as we get closer to that September date, and we'll be in touch.
All right.
Last call for any last minute questions. All right, I think we're good. Well, thank you everyone for your time.
Thank you. Have a good day, everybody.
Thank you.
Thanks, Lauren.